Hello, my true crime lovelies. How are you? Happy Friday. Oh my God. A watch pot never boils. The moment I took my eyes off of the docket, it dropped. I can't go live because I got to go to work, but we'll go live tonight. Not going to bury the lead. I know why you're here. You know why you're here. Let's not delay. We'll get into it. Hit the like button for me if you're here, if you like the content. All right. So, as soon as I clicked on it, it motioned order denying motion of suppression. So you don't have to hold on, but I know you want the details. So let's get into it. Oh, I was so nervous, you guys. I mean, I felt like I knew this is what it was going to be, but until you officially see it, I was reading through it. Let me go back up to the top. Okay, so order on defendant's motion to suppress defendant's statements at OCSO, on defendant's amended motion to suppress defendant's statement at OCSO, and on defendant's second amended motion to suppress defendant's statements at OCSO, Orange County Sheriff's Office. So this is, I'm not going to go through this part, no Liberty, because you basically, it's just repeating. Although it adds here, the cause came before the court on October 2nd. Okay, I got to calm down. First of all, this was filed October 3rd, 7:16:49 p.m. It did not pop up then. So I think this was a manual review. As I was saying, it's the defendant's motion to suppress, state's motion to strike is what was not above, and state's response to defendant's motion to suppress statements, which were e-filed on 9/27. On the defendant's amended motion to suppress defendant's statement, and then the second amended motion. Oh, and a bunch of you guys sent the thing about James Owens being delinquent on his fees and not ready or not eligible as of now to practice law in Florida. So I'm thinking that is why Henderson filed that notice yesterday regarding the discovery. And then hopefully Mr. Owens will get his fees paid by Monday, because you know your girl did what your girl does. So somebody is going to have him get some act right. Okay. A, defendant Sarah Boone is charged by way of information filed 3/23/2020 with a single count of second-degree murder. On February 24th, defendant called 911 of 2020 after finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez arrived on February 24th and spoke to defendant. See also states Exhibit 1. And now Kraynick is getting drip-drab bits of evidence, right? He hasn't looked at any of the discovery. So now he's seeing the interrogation video, the arrival of Kayla Rodriguez, and probably the 911 call. I think I remember Owen saying that was submitted. So Detective Copsel, or Copsel is how they say it. Copsel, a homicide detective with the Orange County Sheriff's Office with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of George Torres's death on February 24th, 2020. Detective Copsel arrived at the scene, very pregnant, within 30 minutes to 1 hour of Orange County Sheriff's Office deputies arriving, was briefed and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. Detective Copsel then made contact with defendant outside of apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Copsel wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews addressed below. So you see how he's laying out the receipts? First, she went through the apartment, Copsel. Then she wanted a search warrant, explained to the defendant that the search warrant was going to be executed. She collected, or CSI collected defendant's phone after they documented the scene. So he's laying it all out. You notice this is not what Sarah's story was on the stand, right? Defendant signed the consent forms prior to the February 24, 2020. Now, in Sarah's testimony, what did she say? That she handed her phone and said, open it, right? It's on the counter, yada, yada. So Judge Kraynick is like, that is not what was in the discovery, in the evidence. Detective Kopsel did not look at defendant's cell phone, including any videos prior to the interviews addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Kopsel then made contact with defendant's ex-husband, Brian Boone. Thereafter, detectives Kopsel and Lowen had an interview with defendant in Detective Kopsel's unmarked Nissan Pathfinder, the specifics, at approximately 5 p.m. So something is wrong here because, one, there's something missing. But two, 5 p.m., if it is 5 p.m., is not after, obviously, 7 p.m. So there's a typo in here. See also states Exhibit 1. Detective Kopsel explained that she wanted to have a conversation with defendant after walking the apartment. Detective Kopsel testified that she would not have interviewed defendant outside of the unmarked vehicle, had no memory of using the word routine, and that everything was explained on the recording. Go ahead, Chelsea. The word routine is not used by Detective Kopsel in any recording. See States Exhibit 1. Detective Kopsel explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Kopsel, and Detective Kopsel's desire to get a further understanding of what happened last night and ask defendant more detailed questions. See States Exhibit. So that is a direct quote from her testimony. And then they put defendant in brackets because that's what she was referring to, even though she didn't say that. See Exhibit 1. Thereafter, Detective Kopsel began reading Miranda as follows. Detective Kopsel, I'm going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? And then we have this here in the footnotes. All 8 questions on Detective Kopsel's Miranda card were read, as Detective Kopsel's Miranda card did not have question number 9. Number 9. Defendant, yes. Detective Kopsel, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective Kopsel, do you understand what I just read you? Defendant, yes. And there's C something. Well, I'm sure it's in the end. Thereafter, Detective Kopsel interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Kopsel confirmed with defendant that no additional communications occurred prior to the second separate recording, and Detective Kopsel inquired of defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which defendant responded, yes. Oh my God, these are receipts. I don't think I've heard the second separate recording because I don't remember hearing Kopsel talking about it being a continuation. But thankfully, she did her job. She confirmed that there was no communication in between recording 1 and recording 2. Because Sarah was trying to imply there were conversations not recorded, like this whole routine business. After concluding the interviews, I'm so excited. Thank you, Judge Kraynick. After concluding the interviews, but before leaving, Detective Kopsel had conversations with defendant had about before leaving, Detective Kopsel had conversations with defendant had about coming to OCSO the next day to address the pending autopsy, and that Detective Kopsel would have more questions. Detective Kopsel did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Kopsel would not have given a specific time frame for returning defendant's cell phone. Detective Kopsel had no memory of receiving a call from defendant on the evening of February 24th, 2020. And the defense didn't offer any call logs because it certainly would be in Brian's call log. I know it's 4 years ago, but defense could have subpoenaed it. Brian could have looked at his old cell phone records. I mean, they're all online now. So defendant's testimony largely agreed with Detective Kopsel's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective Kopsel. As to the February 24, 2020 interviews, defendant confirmed that Detective Kopsel explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. That is damning. And it's on the record. Wow. However, there's no coming back from that. However, there was nothing evidencing defendant being intoxicated or under influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. See States Exhibit 1. So you lied then or now, Sarah? Defendant's statement of making a call to Detective Kopsel became between 9:30 p.m. and 10 p.m. on February 24th from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. Say what now? The court finds this statement lacks credibility. Defendant claimed that before they left the scene, detectives Kopsel or Lowen would return defendant's cell phone to the apartment. On February 25th, 2024, defendant claims that defendant and Detective Kopsel had a discussion regarding the picking up of the I just saw the word pregnancy in my peripheral. I'm like, oh my God. Picking up the defendant's cell phone, specifically that due to Detective Kopsel's pregnancy, defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OCSO was to pick up the cell phone. And then there's a footnote 3. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. On February 25th, 2020, after Detective Kopsel reviewed some of the extraction of defendant's cell phone by digital forensics and attended the autopsy, Detective Kopsel requested defendant to come to the OCSO's office. Detective Kopsel did not want to approach defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla. See also States Exhibit 1. And it was also in the interrogation video, right, where Detective Kopsel said in that recording, remember we said, because that's the one I was worried about, like, oh, was that a tell? Obviously, Sarah was not paying attention. That's why we had you come down here, right? Because Sarah at the end was like, well, I just don't want you guys to show up when Lucas is there. And Detective Kopsel said, we talked about it. That's why we had you come here. So again, that's lending more credibility. There's more receipts to believe what Kopsel said. And as Mr. J pointed out, Sarah has a reason to lie. Her life is on the line. Detective Kopsel gets nothing out of it either way. What is her incentive to lie on the stand? You know? So, oh my God. The state and the defense agree that the February 25th, 2020 interview was custodial. Now, it took a minute for the defense to agree because or to understand rather that the state had agreed, because he was arguing about custodial, and then when the judge called him on it, he was like, oh well, some of that depends on if they're actually in the sheriff's office. Dude, it doesn't depend in this case because the state has already conceded that it was custodial. Let's move on. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Kopsel: just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Detective Kopsel: appreciate you coming in. Oh, should I read? I'm going to read the footnote, and then we'll go back. Approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of prepared written questions and specifically asks, am I getting my phone back? Oh my God. Yes, I'm so glad Judge Kraynick picked up on all the things we've all been saying, like, Sarah, quit playing. Your story doesn't make sense. If you had this on your written list, you knew you were not coming down there for that. That makes no sense. Okay, see State's Exhibit 1. This prepared written statement could not be asked if one was told to come pick up a cell phone. Bow down to the mighty Kraynick. He's my new legal crush. Okay, so I appreciate you coming in. Defendant: yes, ma'am. I want to ask about these when we have a moment. Referring to her pre-prepared written questions, as in she came in with them. They were already written. She wasn't writing while she was sitting there. Detective Kopsel: sure. So obviously we received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it just like we did yesterday. So I'm going to go down to the footnote there so we have a little better continuity. So number 4, just do it. The court notes that this statement is an accurate statement of the law. See Wright v. State, Florida 5th District Court of Appeals, 2014. While Detective Stroop said, this is something I have to do when giving the Miranda warnings, this is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. So if Sarah inferred like it's no big deal because I have to do it, that is Sarah's bad, right? It is rightfully something she has to do. So just like we did yesterday, defendant, normal protocol. Detective Kopsel: just like we did yesterday. Remember, I read you the rights. So she's not really agreeing that it's normal protocol. She's saying it's just like we did yesterday. Do you remember when I read you your rights? Like, that's what we're doing again. Defendant: yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant: sure. All right, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant: no. So she's not feeling threatened. The gun is not threatening her. The tone, none of that is making her feel subservient, is what Owens wanted to imply. Like, all free will sounds like to me. And do you understand what I just read to you? Yes. So you're not threatened and you understand that you have the right to remain silent. Full stop. Whether the Miranda warning sufficient. Oh, I skipped that. See State's Exhibit 1. Oh, the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. The self-incrimination clause of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. Traylor v. State. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Miller v. State. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Okay. So it does not need that level of precision. Quoting Duckworth v. Egan, rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. Alterations in original, quoting California v. Prysock, U.S. Supreme Court, 1981. The crucial test for determining whether police give a warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Quoting Coyote v. United States, 10th Circuit, 1967. So we know Sarah, her age, her background, and her intelligence as one who excels at everything and is a straight A student at least 2 decades ago, would understand these simple words. The Miranda warning provided by law enforcement to defendant at the beginning of the February 25th, 2020 interview is sufficient under both federal law, Florida v. Powell, quoting Miranda v. Arizona, and Florida law, Thomas v. State, State v. Owens. And Judge Kraynick mentioned Owens, State v. Owens multiple times yesterday. So, or whatever day, you know what I mean. In 1966, not yesterday, because yesterday was the holiday, the United States Supreme Court issued its opinion in Miranda and established 4 warnings that are required prior to questioning when a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Specifically, a suspect must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. So actually, Detective Copso went above and beyond because she also did the Miranda within the Pathfinder, where certainly Sarah could have just opened the door and walked out, so she wasn't deprived of freedom of movement in any way. So they're covered. The Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warning identified in Owens Supra. As such, the Miranda warning given to defendant in this instant case was sufficient. Whether the defendant's statements on February 25th, 2020 were coerced. Number 2. To establish that a statement is involuntary, there must be a finding of coercive police conduct. And we know Sarah knows something about coercive, all that coercive control she exerted over Mr. George Torres. Baker v. State. Quoting Schoenwetter v. State, generally, to determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. Oh, and Owens was trying to make a whole other totality, mind-bending, right in front of our eyes. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. And I believe Mr. J proved that. You let me know your thoughts. And I think also why Owens pushed it, because remember at the beginning, Kraynick was like, are we still pursuing that? And he was like, yes, because the state had the burden to prove the voluntariness of it. There was no misrepresentations of the law regarding any defense. See John v. State, no quid pro quo. You give me this, I'll give you that. No directly or specifically made promises. If you tell us this, you'll get your phone back and get to go home tonight. No overt act or threat of force against defendant was proved or claimed. So I would say, yeah, the gun thing was not overt. So yeah, no overt act. No one said, I'm going to beat your butt, Sarah, if you don't tell us that you were having a good day. No fear of material or physical harm. Quoting Denmark v. State. Grant v. State quoting Denmark v. State. No hope of material reward. We'll give you $1,000 and a bottle of vodka. I don't know. No indication that defendant was a newcomer to the law based on the 2 Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. Right. They just told her the day before. So it's not like it's the first time she's heard it. I imagine she heard it in her 2018 arrest. State v. Watson, no indication that defendant is mentally deficient, especially considering the verbiage she used, her mens rea and her corpus mentis. Or what did she say? You know what? Not mens rea, but she said corpus whatever. I have to have my wits about me. No threats, delusions, deceptions, or promises, Martin v. State, and defendant was offered water and breaks. There was no false statements made by law enforcement in order to coerce defendant to go to the OCSO's office on February 25th, 2020, based on the findings above. Under the totality of the circumstances, defendant's statements on February 25th, 2020 were not coerced. Whether the defendant's statements on February 25th, 2020 were voluntarily made. So he's going through each of the points that the defense made, and he's knocking them down. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. Barger v. State. Florida 5th District Court of Appeals, 2006. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2, the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. You have the right to remain silent. Anything you say may be used against you in a court of law. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Factors relevant to consider include 1, the manner in which the Miranda rights were administered, including any cajoling or trickery. I love that word, cajoling. See Miranda, Brewer v. State. The suspect's age, experience, background, and intelligence. So you can't have a 16-year-old with some, I don't know what disorders they might have, but they don't have the compus mentis. No, that's what she said, but that's not intelligence. Wits is what she was saying. Anyway, the suspect's age, experience, background, and intelligence. So, yeah. The fact that the questioning took place in the station house, see Drake v. State, and the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset, see Slimy v. State, Trailer v. State. So... okay, they did not, but it was audio and videotaped or recorded. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. See Chapin v. State. There was no delay in the administration of defendants' Miranda rights. They got to it lickety-split. The recorded February 25th, 2020 interview reflects that defendant understood and acknowledged that she understood her rights. See State's Exhibit 1. Defendant acknowledged that she understood her rights. See Sliney v. State. Evidence supported conclusion that defendant voluntarily waived right to remain silent and obtained counsel when officer read defendant his rights and asked defendant whether he understood each of these rights, to which defendant responded affirmatively. The court reincorporates its finding in paragraph U and paragraph V herein, which further show no cajoling or trickery. Defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. Not above average, not excelling at everything, Judge Kraynick. The February 25th, 2020 interview did take place at OCSO's office and no written waiver was secured. Under the totality of the circumstances, defendant's statements on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver. And this waiver was the result of a free choice on the part of defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the right being abandoned. Orders and adjudges as follows. The motion, the amended motion, and the second amended motion are hereby denied. Let's say it again. Just to say it again. The motion, the amended motion, and the second amended motion are hereby denied. Done and ordered in chambers at Orlando, Orange County, Florida, this 3rd day of October, 2024. E-signed on the 3rd at 19:15:16, so 7:15, Michael S. Kraynick, Tanika's crush, circuit judge. Certificate of service. This 3rd day of October, using the Florida Court e-filing portal. Accordingly, a copy of the foregoing is being served on this day to all attorneys / interested parties identified on the e-portal. State of Florida, Sarah Boone, and her 3 attorneys. This I also want to highlight because people keep saying Hobson is still on the case. I don't know why it keeps appearing on the notice of hearing or the minutes. I believe there's just a copy and paste happening and that part is not being adjusted. Hobson nor Hobson's legal partner are involved. These are Sarah's 3 attorneys. We know that because they are continuing to get all of the filings, motions, correspondence related to the case. So page 10 of 10. Oh, they didn't do the attachments. Okay, well, we know what they are. I think I'm going to put together a video. Well, let's not get ahead of ourselves. Let's just celebrate this moment. And yes, I wish it had come out at a time that I could go live with you, but you know, it is what it is. It's here. I'm glad it's here. I didn't want to hold this. I didn't want to hold you. So now you know. And I will talk to you guys this evening. Toodles.